Good morning. I am Murray Sogsveen. I serve as a commissioner on the North Dakota Ethics Commission. I will be acting as a hearing officer for this morning's public hearing. It is now 9:30 a.m. on July 14, 2025, in the Sakakawea Room at 600 East Boulevard Avenue, Bismarck, North Dakota, and online on Microsoft Teams. At this time, I will open the hearing. This public hearing has been called for the purpose of allowing all interested individuals an opportunity to submit information concerning proposed Ethics Commission rules regarding disclosure requirements for public officials' travel. The proposed rules implement North Dakota Constitution, Article 14, Section 3, Subsection 2. The proposed rules would require public officials to file a travel disclosure statement with the Commission for Party-Funded Travel, require public officials to report policy-monitored travel, and set penalties for noncompliance. Information gathered at this hearing will be transmitted to the entire North Dakota Ethics Commission for its deliberation and final decision. The Commission will not be responding to comments at the hearing. The comments received will be considered with any written comments that are received, and the Commission will present its consideration of all the comments in writing. You may request a copy of the written response, and one will be provided to you. This hearing is recorded, and we ask everyone to speak up to ensure the recording is clear and accurate. Please identify yourself for the record before you speak. Everyone present will be given an opportunity to speak, present online or in person. If you have prepared a written statement, a copy of your statement is appreciated and will be helpful. You may email any written statement to ethicscommission@nd.gov. If you are appearing in person, we ask that you sign the registration sheet before you leave today's hearing. At this point, I will open the hearing for comments. I invite those personally present to first comment. When all present have commented, I will invite those online to comment. Governor Armstrong, I invite you to the podium.
While I'm writing my name down, I will tell Ms. Vindistaka's story, which I think she uniquely will appreciate. I try to be fairly punctual, and I learned it very early on in my legal career through massive calendar mismanagement. I ended up 25 minutes late to a federal court hearing in Fargo one time. And the judge was 10 minutes late to the hearing, and he spent the first 10 minutes yelling at me for being late. So since then, I have always tried to be on time and respect your guys' time. So that.
Well, Governor, in the Army, we used to say that if you're on time, you're late.
Yeah, I had a baseball coach that said if you were 10 minutes early, you were 10 minutes late. And I didn't understand that. I'm like, just schedule, just tell us to be here 10 minutes early. But I think that's accurate. I would say trial lawyers are a little different. The good ones are usually right on time. But I appreciate it. Thank you all for allowing me to do this. I actually think, for the most part, this is a good idea. I think that having a central depository for being able to look at and making sure that third-party travel is doing it. I'll tell you the same thing. I mean, my calendar is subject to open records, but you'd have to request that to do it. We had to do this in Congress. Sometimes it can be a little cumbersome, but I think overall it makes a ton of sense. I do, and I think my concern is with subsection 4. And the reason I bring this up is because I understand late fees. I understand escalating them at 11 to there and all of that in subsection 1 and 2. But 4 is not a fee. It's a penalty. It's a fine. if anybody gets hit with $5,000, the general public's not going to treat it as a fine or as a fee. They're going to treat it as a fine. It's going to be reported as a fine. It's going to be that. I have 150, and again, I think there's some difference in distinction, or at least maybe not legally, but practically. I mean, we have elected officials, we have statewide, we have legislators, we have all of that. But I have 154 boards and commissions to which, and I honestly don't have any idea how much or if at all any of these people go on third-party travel. I could see water commission, if there's a seminar somewhere that somebody's paying for, or historical society, but I'm not sure the engineering board or the electrical board is going on a lot of third-party travel, but I simply do not know. But my question, comment / concern with the $5,000 fee is it is based on conduct. It reads like a fine. And so I think once that occurs, there has to be some due process built into it for how you appeal it, how you contest it. And then I think there needs to be a real conversation about the jurisdictional side, because a fee that goes to a collection agency that becomes administrative. I mean, it's significant, but it still becomes administrative. And there are 1,000 of these, or 154 of these boards that exist, that you could resign from the board before the 15th. And I don't know if you guys have thought about when jurisdiction ends, when jurisdiction begins. Like if somebody who's been off the board for 2 weeks doesn't file their third-party travel, but they're no longer a public official. They were a public official at the time the conduct occurred, but they're no longer a public official at the time that the travel disclosure is required to be filed. And I think those, with something it's a felony level fine. I mean, it's a $5,000 fine. And I know there was debate during the session. You guys can deal with whether or not that exists or doesn't exist. But I do think when you get to that level here, because it's based on conduct, it's based on failure to disclose or knowingly falsely disclose, which makes it a fine and a penalty more than a fee. So I think there are some questions as to how number 4 would be applied in those scenarios. And I would really encourage the commission to look at it, not just, like I said, statewide, and our calendars are open record. Legislature does this in their own, and making sure you're coordinating with them so it doesn't become duplicatively burdensome for legislators, I think is something you could do. But I'd really look at it from the viewpoint of that guy serving on the electrical commission board and that volunteer guy, and how this rule can work for them as well. Because I need to know, because I'm going to tell them about this when they apply for the board, or when we're trying to fill these positions. And I could tell you, it's not super easy to get a lot of people to apply to some of these boards. We actually have an entire committee trying to streamline that over the interim and working through that. So that's the piece of this that I think needs to be fleshed out in a significantly more detailed way.
Thank you, Governor. That raises an issue with public officials, because I served on a committee quite recently, one appointed by the governor. So when you appoint a person to one of those 154 committees, they become a public official, and they're subject to possibly this rule.
Well, I think they are subject to this rule.
Open records,
yeah,
open meetings, and a number of other things. And we don't have, the Ethics Commission doesn't have information about who's serving on those boards, and
I do think there's an overall arching conversation that needs to occur is when jurisdiction begins, when jurisdiction ends. You have somebody in the pipeline for a $5,000 fine that resigns from the board. Maybe they resign because of this. Maybe they resign for a different reason. I have people get on and off boards all the time. And then where in that process does jurisdiction begin? Where does it end? But I also think if you have the ability to, this is the defense attorney in me. If you have the ability to level a felony level fine, there has to be some processes built in place to contest it or appeal it and be able to utilize that, because it is more than a $50 late fee.
Yeah. commenting more on that, my service on that committee, there was little information provided to me as a committee member about what my responsibilities were or liabilities were as a public official. I mean, that's just a comment. So
I have a weird question. If you would indulge me a little bit, I was going to come again on Wednesday, but I got to go testify in DC on Wednesday. So if I could just, I would like to address the commission on an unrelated matter quickly.
which I will pass on to the commission.
Okay.
Yeah.
So paying for daycare or security isn't an ethical question. And the reason I know this is California allows it, Louisiana doesn't. That doesn't make California inherently more legal than or more ethical than Louisiana. Some states allowed daycare and security paid from their campaign accounts. Some states allowed security to be paid from their official accounts. Some states allow only allow it to be done from their personal accounts. Paying for daycare or security is a policy question. It's a political question, and it ends up being a legal interpretation of the Century Code. It should be subject to hearings, should be subject to debate, and it should be subject eventually to a vote. It's a valid question as to whether I can pay for the use of campaign funds to use my oldest daughter to pay for my younger sons, to babysit my younger sons during a campaign event, or buy a gun or a gun safe. But because of the immunity that exists in the Century Code, with one opinion, the Ethics Commission has taken away from both the legislative body and to implement the law and the Secretary of State to administer the law, and have essentially made two other constitutionally elected entities irrelevant in the process. I mean, it's the legislature's goal to write campaign finance law, and it's their duty to do it. It's the Secretary's, this doesn't affect the governor's office at all. And it's the Secretary of State's duty to implement that procedure. And now, regardless of what the legislature thinks about that, or regardless of what the Secretary of State interprets that, because of the way the Century Code is written, their determinations become irrelevant, at least until the next legislative session. And when agencies, and I mean this with all respect, but when agencies expand their authority simply because they do it or they think they can, sometimes I get annoyed, but I don't get particularly surprised. I was in DC for 6 years. But when those agencies expand that power at the detriment of two other constitutionally mandated positions who are elected by the voters, I think it is my role and my obligation as the governor to point it out and ask you to strongly consider that when you do this, because of the immunity that is granted in the Century Code, you are expanding the Ethics Committee's authority in this space at the detriment of both the legislature and the Secretary of State's office. And so I would have done this on Wednesday, but I got to go to DC. And this was the only public time I had to, or well, I could have done it Wednesday, but this is the only public time I had to actually say what I think is important. So,
Governor, if you can't attend on July 16th, would you be interested in meeting with the Ethics Commission at the next time?
This is constitutional. It needs to work. It has to be good. There's some things in the Constitution that I think make this a little more difficult. I think I've told many of my friends that you go back in time and pass, I think it was Representative's Mock's bill, we end up in a situation, but I don't mean it to flamethrow. I don't mean it critically, other than it is critical. I think in this case, without the ability to vet legislation, without the ability to debate legislation, without the ability to do any of those things, we put by fiat into an opinion that wasn't really an ethical question. It was a policy question, and it was a legal interpretation of current North Dakota Century Code.
Well, on behalf of the commission, I invite you to the next time your schedule will permit it.
I thought it worked on Wednesday, and then the United States Senate asked me to come testify. So I appreciate it. Thank you.
Thank you very much. Having no presenters in the Sakakawea room. I'm inviting anyone online who wishes to present at this time. Mr. Fagley.
Yes, this is Representative Fegley from District 4B. I have a concern from the legislative standpoint. Two issues. One, the fact that we're a citizens legislature and all these individuals do something else besides being a representative. In my case, I'm on a bank board, and the reality is every year they go to have a strategic session in Arizona. So I'll be traveling on third-party pay from a bank board. I can probably get the cost of the travel and hotel. But one of the concerns is when they take us out to lunch and bank pays for the whole lunch, trying to figure out what the cost of my meal was, it's going to be a little bit of a challenge. That's one issue. The other issue is I'm an EMT, and I get paid $50 for every time I go on an ambulance run. Well, that's travel. Am I going to have to file every time I go on an ambulance run for the $50 I get paid to do that? I do have a suggestion that in the citizen legislature, we put in our process that we disclose other organizations that we belong to. In doing that, you could probably exempt those organizations that the legislators have already disclosed that they belong to from this travel voucher thing that you're proposing. Thank you for hearing me.
Representative Fagley, thank you for the comments, and thank you for serving on a bank board, and thank you for serving on an as an EMT.
You're welcome.
Are there any other individuals who would like to present at this time online? You may signal by raising your hand online, or it is 9:49. We will keep the record open until 10 o'clock to allow anybody who wants to speak to signal online. Thank you for attending this hearing. All of the information gathered at this hearing will be provided to the commission, which is the decision-making body. The record will be held open for written comment until July 28, 2025. Any written comments may be submitted via email to ethicscommission@indy.gov or mailed to 600 East Boulevard Avenue, Department 195, Bismarck, North Dakota 58505. It appears there is no further testimony. Accordingly, I am closing the hearing on proposed Ethics Commission rules regarding travel disclosure requirements at 10 o'clock. Thank you for attending.